And CBS News legal analyst Ricky Kleeman has been following the latest developments as they, in fact, do continue to develop. Ricky, lots to get to here, but as of now, the government has a deadline of today to justify the president's executive order, even in the face of this mounting legal backlash. So right now, first and foremost, to that argument, how long do we see this temporary restraining order last? And what do you make of the additional arguments we might see from the government?
What we're going to find today is a very quick briefing schedule. The government has a brief that is due, and then the state of Washington and Minnesota, as the plaintiffs, have the ability as well to argue by brief to a 3-judge panel of the Ninth Circuit Court of Appeals. They will likely issue a very quick decision. They don't need a hearing on this. They can do this on the briefs. And that hearing, that briefing schedule happening today could cause a decision as early as this evening or perhaps even tomorrow. Now, that decision is either going to extend the temporary restraining order, meaning that the judge who decided on Friday that the executive order no longer applies, that could just get extended for a period of time, or they could overturn it. So then what happens, I bet you ask?
There you go.
Well, you have two roads here. Whoever loses can go up to a full bench of the Ninth Circuit, or they could even try to pass that up and go directly to the United States Supreme Court.
Is this getting to the Supreme Court?
Absolutely,
There's no way
100%. One side or the other, whoever loses is going to go to the United States Supreme Court. Now, that's when things start to slow down, because it is not just that simple to say, look, this is an emergency. We've got to get here really quickly. You could get to a single justice, but are you going to get to a full bench? And in the meantime, all these people are on this seesaw who are trying to get in, who have visas to be able to get in, let alone the refugee problem. And so they're like in a squeeze. They got to move fast.
So we see the window open right now. They can continue to come, the people with the visas that were not canceled in the initial aftermath. Then there are a lot of if-wins, but it seems, if nothing else, there are still going to be elements of chaos, if only because the parts of the executive order called for a 90-day ban, 120-day ban. And as things start to slow down, those numbers, we're going to hit those numbers, it would seem, one way or another.
Well, the government has a variety of ways to proceed here. Number one is the government could redraft the executive order in a way that might pass constitutional muster. It wouldn't take much redrafting. Number two is the executive, that is the president, could work with the Congress to get a law passed. And number three, when we deal with these temporary issues, the whole point of the 90 days and the 120 days was to study the problem. Well, go ahead and study the problem, so that at the expiration of that time, you can come forth as the executive and say, okay, we've done our studies, and now this is our new order, whatever that may be.
For those watching, how is it, again, that the decision of a federal judge in Washington can now apply nationally? I think a lot of people are just wondering, why isn't this a circuit by circuit?
Well, I think that that's really a great question, because I think it would be the question that the lawyers would ask. Usually what you have are different opinions between or amongst various circuits. And then because of the conflict, it goes up to the United States Supreme Court. This judge says, look, what you have here is immigration policy. And by immigration policy, it needs to be uniform, that we cannot have differentiation. And they go back to what happened during President Obama's time, when you looked at immigration policy decisions issued by one court. So, in essence, what you have is what we call comity, C-O-M-I-T-Y. That comity is to have the district courts, the various federal courts, act so that we don't have a kind of disruption. If you wound up with, say, Boston says, nope, absolutely, the executive order stands. Sorry, plaintiffs, you can't prevail. And you have Washington saying, well, wait a minute, yes, you can. Then what happens is all these plane tickets have to get changed. Everybody wants to come in through Minnesota and Washington, who are the plaintiffs in the case on the West Coast, and the rest of the country is in chaos. So that doesn't make any sense either. So this judge does have the right to make a national order. And now, of course, you have these filings by all these various tech companies that have said, look, this hurts our business all over the country, which was part of the argument before the judge in the Washington and Minnesota case.
Meanwhile, so that's the law. We also have the optics in play here. And I wonder your sense of the ramifications of the president referring to the judge in this case as a so-called judge, saying, and I quote, if something happens, blame him and the court system, end quote. I realize that free speech allows for whatever it is that might be said, but are we going a bridge too far here?
Well, I'd certainly say it's not helpful. I've always believed, and I was always taught as a lawyer about the rules of civility, that what we were supposed to do, whether we disagreed with a judge's decision or applauded for a judge's decision privately in our own homes, was that we were supposed to be respectful. Now, I agree with you. The president certainly has the same right that any other citizen in the United States has, which is to criticize a judge if he so chooses to do, which he has done here, and he did with the Mexican judge, which he talked about in a case involving his own assets. But it doesn't help the situation. I don't think that legally it makes a whit of difference. But we do have to have respect. We have to remember that there are three branches of government. That's how our country was founded. And they are equal: executive, that is president; legislative, that is Congress; and, of course, the judiciary. And this judge, Judge Robart, in the district court, federal court in Washington, did add on a conclusory paragraph, which I thought was intriguing, where he himself says, look, it's not the court's job to decide policy for the United States of America, but it is the court's job as a third branch of government to make sure that policies done, in this case by the executive or by the legislative branches of government, meet constitutional muster, that they pass it. And in this case, we don't know what the basis is for this judge's decision on Friday. He doesn't say it's equal protection or due process or establishment or free exercise of religion. But what he does say is that the plaintiffs, the states of Washington and Minnesota, have a basis, a substantial basis of prevailing on the merits. Well, we're going to see what happens this week by the Ninth Circuit.
And so if the press is referred to as the opposition party by a White House, again, the danger of seeing the judiciary as the opposition branch, I suppose, of government at this point. The ramifications far-reaching. And here we are just a couple of weeks in. Rikki Klieman, for the first of her many appearances, I have a feeling, through the Trump administration. Rikki, as always, we appreciate it.
Thank you, Josh.